All right. The 14A District Court for the County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson is presiding.
You may be seated. This is my deal here.
Yes,
All
I'm
right.
trying to get.
Can he unmute himself or no? Oh, there we go. All right. Court does call the case, the People versus Boyce Williams.
Yes, sir.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Williams.
Mr. Williams, state your name, please, sir.
Boyce Williams.
Thank you. All right, what are we doing on this case?
You know, this Mr. Childers is assigned to this case. I did have an opportunity to speak to him prior to the matter being called. We both agreed that that the matter would be set for a preliminary examination.
And all discovery is complete then.
To my knowledge, yes.
Okay, which facility are you in?
He's at Cooper Street, Your Honor.
Cooper Street? Okay, so I'm still gonna will they get him down to?
Yeah.
They'll do it. Okay.
Yeah.
Preliminary exam will be set in person July 20. Well, no, that won't be 2 weeks, so it's gonna have to be the 30th. Give a full 2 weeks. July 30th, 2024 at 9 a.m. That is before me. Bond on this matter will continue.
Thank you, Judge.
All right. All right. Thank you. Thank you, Mr. Williams.
Yes, sir.
Court calls the case of People versus Tommy Lee Clark.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Clark.
Your name?
Tom Clark.
Your Honor, at this time, I'd ask to set the matter for preliminary examination.
Discovery is complete.
To my knowledge.
People have their witnesses available the 23rd. Who's on this case?
Mr. Ganatra.
Oh,
I'm just checking with.
yeah. No, that's fine.
Summer season. If I could have an extra week.
All right. Preliminary examination. Without objection, July 30th, 2024, 9 a.m. That's before Judge.
Fresh out.
Fresh hour. Bond will continue.
Thank you, Your Honor.
Recalls case People versus Kaylon Harris.
Good morning, Your Honor, or afternoon, Your Honor now. Sam Bernstein, recently appointed, here with and on behalf of Mr. Harris.
Okay, state your name again.
Keila Harris.
All right. There's your attorney right there. Told you we get you one.
Your Honor, just asking for the briefest of adjournments to get up to speed and work out a plan.
All right. I'm gonna do 1 week and that way we can get it moving. So I'll set it for July 18th. Next week, 2024, 9 a.m. All right. His bond will continue at this time. All right. Thank you, sir.
Thank you, Your Honor. Have a great rest of your day to you and your staff.
You too. Court calls the case of the People versus Leroy Diggs.
On behalf of people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Diggs. Fortunately, will you please state your name for the record?
Leroy Diggs.
Your Honor, we're asking that this matter be set for a preliminary examination.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available the 23rd. Preliminary examination in person, July 23rd, 2024, 9 a.m. That is before
Judge Barr.
Judge Barr. Bond will continue.
Thank you.
Court calls the case People versus Wayne Eagleson.
First Assistant Public Defender Quina Anderson on behalf of, but not with Mr. Eggleston. Your Honor, Mr. Eggleston is in custody at the Macomb County Jail. He has a hearing scheduled for tomorrow. He's on a bond of $3,000 there. We would ask for an adjournment. I do believe this case is already in warrant status due to the bond violation.
Yes. So we'll leave the bench warrant out. And his hearing is tomorrow, you said?
Yes, Your Honor, it's tomorrow.
Well, we'll set him for July 25th. Thank you. 2024, 9 a.m.
Thank you.
Thank you. I don't know what I do without you. Court calls the case People versus Galen Foster.
Good afternoon, Your Honor. Amy Reiser.
Good afternoon, Judge Brian Bowling on behalf of Mr. Foster. Your Honor,
Mr. Foster, can you state your name, please?
Galen Foster.
Thank you, sir.
Your Honor, Mr. Foster was just arraigned last week on this matter. From what I'm able to tell from our PD office records, we don't have any discovery in this case yet.
You're requesting an adjournment,
That would be, yeah, that's
July 25th, 2024, 9 a.m. Bond continued without objection.
Thank you, Judge.
Thank you. Thank you, sir. Court calls the case People versus Drayvon Goodlow.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Goodlow, who should be present via Zoom. Mr. Goodlow, can you please unmute and state your name for the record?
Draymond Goodlow.
Thank you.
Thank you, Your Honor. We are respectfully requesting a very brief adjournment in this matter so I can have one last discussion with my client before next steps.
August 1st, 2024, 9 a.m. Bond continued.
Thank you very much, Your Honor. Thank you, Mr. Goodlow. You can log off now.
Court calls case People versus Tyler Harlow.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Harlow. Mr. Harlow, will you please state your name for the record?
Tyler Harlow.
Thank you.
Your Honor, we are still awaiting labs in this case. So I don't know if there's a timeline.
I have not received a time, but officer was going to follow up with the lab. I haven't received a timeline. Could we go out about 3 or 4 weeks?
Probable cause conference, August 8th, 2024, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Casey Hill Casabo.
Ryan Bowling, Assistant Public Defender on behalf of Ms. Hill Casabo. Please state your name for the record.
So my name on there is Casey Hill Casper, but my actual legal name now is Casey Casper.
Casey Casper?
Yep, K-A-S-T-E-R.
Okay, like the ghost.
Thank
Yep.
you.
Okay.
Your Honor, a plea offer was made to my client today. She would like an opportunity to discuss that further with my office with some family. So I just asked for an adjournment.
That objection, August 1st, 2024, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continue. Thank you, ma'am. Court does call the case of the People versus Dewan Holston. Is he?
Assistant Public Defender Natalie Pate with and on behalf of Mr. Holston, who is present via Zoom. Mr. Holston, can you please unmute and state your name for the record?
As away from the Mr. Holston. I'll pass it. He's here, but oh, hold on.
He just dropped out.
He dropped. Okay. Well, or is that him? He dropped. No, he didn't drop. He shut his camera off. I'll pass it. If you can maybe, I don't know if you have a number to text him or.
I do, Your Honor. I will reach out to him and see what. Thank you, Your Honor.
Court calls the case People versus Richard Hughes.
Attorney Jake Lazar asking permission, persuasion to rule.
What's your name?
Jake Lazar.
Oh. You been before me before?
No,
I didn't think so.
first time. I have a very distinct face. But
Okay, well, I'll let you go. Go ahead.
asking permission and persuasion under Rule 8.120 under First Assistant Public Defender Killian Anderson.
Oh.
Explain it all.
That's, you're with Anderson.
Yeah.
I'm sorry. Who are you representing?
On behalf of Richard Hughes, who is present in the Zoom.
Okay. Where are you from?
Novi.
Novi?
Yep.
Okay. Michigander?
Well, a Michigander. I go to school in Ohio, though. I'm still a Michigander.
Where do you go in Ohio?
Toledo.
Oh. What was your undergrad?
Wayne State.
Okay, you're good.
Okay.
All right, now permission to practice is granted.
Your Honor, at this moment, we're requesting a date for a preliminary examination.
Are you gonna handle it?
Hoping to.
Really?
Why not?
He's gonna do it? Sweet. Mr. Hughes is like, what? Is all discovery complete?
Yes.
It is?
Yes.
Would the people have their witnesses available the 30th?
I believe so, Your Honor.
30th, because it's gonna be preliminary examination, July 30th, without objection, 2024, 9 a.m. That's before me. Bond continued. All right, that's in person, sir. Look forward to seeing you, counsel.
Thank you.
All right. Thank you, Mr. Hughes. Court calls case People versus Lakita Johnson.
Yes.
We have the people.
She's my iPhone one, I think. Got it.
Brian Bowling, Assistant Public Defender on behalf of Ms. Johnson, Your Honor. At this time, we're requesting the scheduling of an exam. To my knowledge, all discovery is complete.
Discovery is complete. People would have their witnesses available the 23rd.
No, Your Honor, if we could have a later date, I believe that this is a situation where it's a child abuse case and she's in custody as a child, so I'm gonna have to have the officer serve her with a subpoena to bring the child to court.
Okay.
Yeah, later date.
30th or the 6th.
August 6th.
So I'll set preliminary examination in person, August 6th without objection, 2024, 9
Is that the day I
a.m.
have to bring my daughter?
Yes,
Yes, it is.
Okay.
that'd be before Judge
Period.
Perry. Bond will continue. Thank you.
Mm-hmm. Thank you.
Thank you, ma'am. I got it. Court calls the case People versus Emre Kazan.
Assistant Public Defender Jay Bellinger on behalf of Emre Kazan.
You only give her one case?
No, she had two.
You only gave her two cases?
She can have all of them if she wants, but I don't know that it's like that.
All right.
Can you say your name, please?
My name's Emre Najati Kazan.
All right.
Sorry, nervous.
What are we doing on this? Yes, you may.
I'll be right back.
Hang on.
Thank you, Your Honor. And as far as what we're asking for, it's just a couple weeks adjournment so that we may continue working on a resolution for this matter.
All right. Probable cause conference. Given the circumstances, I'm going to go August 8th. I'm going to give you a little bit more time than that. Okay.
Thank you.
2024 at 9. I will also record to reflect the added bench conference in this case. This bond will continue. However, I will delete the no contact provision and add the no non-consensual contact with the victim in this case.
Thank you, Your Honor.
Yeah.
Thank you. You're all.
Court calls the case People versus Muhammad Khalil.
Andrew Childress on behalf of the people.
Public Defender Queen Anderson with on behalf of Mr. Khalil, who should be appearing by Zoom.
Mr. Khalil, can you state your name, please, sir?
Muhammad Khalil, Your Honor.
I have a bond violation.
Yes. May we approach briefly?
On this matter, I understand that the parties, record to reflect there's a bench conference. I understand the parties, there is a resolution. However, I'm not going to take that resolution today. There's a bond violation pending where you went for the intake, but did not go back. I'm going to re-refer you to community corrections. You are to go in there for, I guess it's going to be a re-intake, and then you are to take testing as ordered. Do you understand that, sir?
Yes, Your Honor.
I'm also going to require defendant must appear in person at the adjourned date. I'll at this time have his bond continue. And I will adjourn this out to August 1st, 2024, 9 a.m.
Thank you, Your Honor. Mr. Khalil, call that number that we gave you. You do need to go to community corrections today. If you have any problems or questions, give us a call back. And the prosecutor did agree to leave the offer open to the next court date, okay?
All right, sounds good. Thank you very much.
Thank you.
Bye.
Court calls the case People versus Jade Lathan.
Kind of the order Assistant Public Defender on behalf of Ms. Lathan, who is approaching.
She would have been up here by now if it hadn't been for Anderson getting in her way. Your name, ma'am?
Jay Ruth Bay, beneficiary of the principal, Jade Lathan.
Okay.
Your Honor, this is the date and time set for a competency hearing. Does the court have a copy of the competency report?
From June 24th, I do.
Yes, Your Honor. I've also received a copy. I've had an opportunity to review that at this time. I would stipulate to its findings.
People also stipulate?
Yes, Your Honor.
All right. Based upon the review of the report, court would find that the defendant is competent to stand trial, would specifically indicate the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. I'll need an order, counsel.
I will provide that order, Your Honor. With regard to the probable cause conference, I did call my client yesterday and left a voicemail. I also sent her an email, but I was not able to speak to her. I would ask for an adjournment so that we can discuss the case.
Probable cause conference, I will set it for August 1st, 2024, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, ma'am.
Come back here.
So then recall the case of the people versus Dewan Holston. I think he's here now.
Hey, Mr. Sinatra, people.
Oh, he was. Mr. Holston,
Yes, sir.
you got a camera? I saw you
Yeah,
for a minute, but
This damn thing. I mean, this thing is messing up. It ain't even let me turn my camera on now.
For the record, Assistant Public Defender Natalie Pate with and on behalf of Mr. Holston. Mr. Holston, are you?
I saw him. Yeah, okay, there he is. Kinda. All right, there he is. Okay.
Thank you, Your Honor. Mr. Holston is going to be waiving his right to a preliminary exam. I do have a waiver form here, which he has reviewed electronically, and I signed on his behalf with his permission.
All right, Mr. Holston. Is that
Yes, sir.
correct? You're waiving your right to have a preliminary examination?
Yes,
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
yes,
You understand that you'll not have the hearing, but you'll proceed to circuit court for further resolution.
yes,
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, Your Honor. We acknowledge receipt of the information. My client stands mute, and we waive any further reading.
Defendant having waived formal reading, standing mute to all 3 counts, court will enter a not guilty plea. Pretrial will be set for
August 19th at 1:30 before Slay Monday.
August 19, 2024, 1:30, Slay Monday.
all right, thank you.
Bond continued. Thank you, sir.
Thank you. You have a blessing.
All right, take care. Yes.
Thank you, Your Honor. Thank you, Mr. Holston. You can log off now.
Anything else? No, not till 1? Okay. We're on track though. All right. Court's gonna stand in recess.
All right.
Case people versus Deshaun Lee.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Leith, who stands to my right. Please state your name for the record, sir.
Deshaun Lee.
And for the record, Matt Nagel for the people.
I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
All right. The plea form indicates that the defendant would be pleading no contest to the charge of attempted resisting and obstructing a police officer, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the entirety of the plea agreement is from the court's perspective. Is that correct?
That is correct, Your Honor.
Yes, Your Honor, with just one clarification. I did not mark it on the plea sheet, but I should have indicated that when the court accepts either a no contest plea or a guilty plea, that the offer is not contingent on just a no contest.
Got it. It's marked no contest, and I have reviewed the police report. So is that the way you wish to proceed?
Yes, Your Honor.
All right. Very good. May I have it sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Deshaun Lee.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things about a no contest plea you need to understand. First of all, it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Also, sir, what I I need you to understand that I'm taking your plea, but I would not be your sentencing judge. And you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, sir.
All right. The basis for the no contest plea?
Potential civil liability, Your Honor.
All right. Understanding all of that, sir, you still wish to plead no contest?
Yes, sir.
And to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
Has he signed an advice of rights form?
Yes, he has, Your Honor. I do have it here with me.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
Nope.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to
No,
get you to
sir.
plead no contest? Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Ann Arbor Police Department report for their case number 24-16-388. Counsel, any objection to the court having reviewed that report?
None from the defense, Your Honor.
None from the people, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is said. Yes, Your Honor.
Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 8th at 1:30 before Judge Valvo.
August 8th, 2024, 1:30 before Judge Valvo. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Thank you. You too, sir. How come nobody has full pants? Court does call the cases of the people versus Ryan Miller. All 5 cases.
All right, I'm on, you guys.
Okay, yeah, I got you. Who are you?
Ryan Miller.
I'm Ryan Miller.
Ryan?
Ryan Miller.
I called Ryan.
Oh.
It's okay. No, it's okay. You're good. We'll
That's
get to
funny.
you.
There was a Brian Miller.
I'm like, I got 2 of them. Oh, no. All right. So who's these attorneys?
Mr. Overwater?
I'm with Ryan Miller.
That's who I called.
I'm talking to the wrong guy. This is perfect. This was the Mr. Miller I wanted to be here. Your Honor, Mr. Miller appears from Oakdale Treatment Center in Canton. I would ask to just adjourn the probable cause conference so that I have a better opportunity to speak to him and resolve all of these matters.
All right. How much, any objection from the people? How much time do you need there?
Mr. Miller, how much longer are you at Oakdale?
I don't know if there's a bed open at transitional yet, so I might get an extension, maybe 2 weeks-ish. Just to be
Okay,
safe.
gotcha. You're waiting for a bed to open in transitional house?
Yes, sir.
Is that what it is? Okay.
Yes.
Let's do this then. I'll adjourn all these to, where do we go? August 8th, 2024, 9 a.m. or as your invite indicates. Bond will continue.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
All right. How's it going for you?
Good, good.
Good. Okay.
Yeah, I'm having a blast.
Okay.
Right.
All right, Mr. Miller, you take care.
You too. I'll see you next month.
Yes, sir.
All right, bye.
Court calls the case of the people versus Frankly. Is it Lynn you on?
Mr. Ganatra for the people. Sorry, what did you say the last name was, Your Honor?
Lynn Ewan.
Okay, thank you.
Is that what, did I get it
Yes,
right?
that's
Close.
Assistant Public Defender Jay Ballinger on behalf of, how do you say your last name?
Lynn Ewan.
Lynn Yu.
Lynn Ewan. Okay.
And Your Honor, I suppose I'll let Mr. Ganatra get on the record.
I am ready.
Oh, you did? Okay. My
A while
apologies.
back.
So
Go ahead.
I don't know exactly how to articulate this, Your Honor. I do need to see, I've talked to Mr. Ganatra. We are going to be asking for about a month here for an adjournment to track some progress in terms of restitution being paid. After speaking with Mr. Ganatra, it's my understanding that we need to change the bond to reflect the restitution amount in order to accomplish that. It's my understanding that you also would be paying out of this court.
That what now?
That you would also be paying the restitution to this court.
That is correct.
Okay.
And so you just, how much is the,
Your Honor, the amount in the police report is $2,299.
Okay.
98
all
cents.
right.
Thank you.
All right. What will indicate defendant may pay the $2,299.98 as restitution or as bond to be held for restitution. And how much time out are you gonna need to?
We're asking for about a month now, right now, Your Honor, to start tracking the progress. He is willing and able to put down $100 as early as today. They advise that they can pay about $100 a week. They know that that'll need to be paid in a larger sum throughout the course in order to accomplish this sooner than later.
Probable cause conference, I'll adjourn it to August 13th, 2024.
Thank you, Your Honor.
9 a.m. That's a Tuesday.
Okay.
Bond will continue with that added condition.
Thank you.
Thank you. You've had everybody should this with us. Yeah, she's still working. She's a little slow. Court calls case People versus Brian Miller.
Representing Mr. Miller. Mr. Miller, will you state your name for the record?
Brian Miller.
We all know now. Okay.
Are you Brian Miller?
I said Ryan. I thought he said Brian.
Okay. So we are requesting two things, Your Honor. First, we are requesting an adjournment. I did speak to the prosecutor and we've started negotiations. So we need some additional time to continue that. Second, Mr. Miller now resides in Utica. And so we.
New York?
Utica, Michigan.
Oh, okay.
Okay.
I'm 59 in Van Dyke, roughly.
Yeah, I got it. I know where that is. I thought it might be New York. I didn't know. Go ahead.
No, it's a brain injury plates. They moved me to one in Utica, so I don't have a Washtenaw Guardian any longer. It's a Waterford Guardian, so it's out of this county now.
Got it.
So we are requesting that he be able to appear by Zoom, and I will submit the written one if we aren't able to request that orally today. And his guardian was not able to be here today, but she would also be participating by Zoom if the court would allow.
Okay. Yeah, if you submit the forms, I don't see any reason why we can't have that happen.
Okay.
Probable cause conference, August 1st, 2024. Bond continue. Thank you.
Thank you.
Your Honor.
Thank you, sir. Court calls case of the People versus Alexis Naveen.
Under Hannah Apple appearing on behalf of Ms. Naveen. Will you state your name for the record?
Alexis Naveen, Your Honor. Thank you.
How are you, Ms. Naveen?
I'm well. Thank you, Your Honor.
Thank you. Your Honor, we are asking for a 6-week adjournment. I did make a referral to our social work division for a mitigation letter. Additionally, Ms. Naveen is going to be going into inpatient treatment on the 24th of this month. So I'd like some time for her
Okay.
to.
So she's going to go into inpatient 24.
Yes, she's being admitted on the 24th. And obviously the length of that will be determined once she's there and assessed. And then additionally, the mitigation letter does need some time for that.
6 weeks up. Yeah. From today. Yeah, I guess it is. Yeah. They got you out that day, didn't they?
Pardon?
They got you out of the jail that day, the last time we were
Yes,
here.
Your Honor. Yes, Your Honor. Thank you, Your Honor.
Okay. All right. Probable cause conference will be adjourned. Let's just put it out to August 22nd, 2024. 9 a.m. Bond will continue. There's not the possibility of a Veterans Court resolution to this?
We've discussed, I was speaking with Ms. Pearney on it as well, but some possibility of either veterans or mental health court, but I thought the best way, we want to get the mitigation letter.
Get the mitigation. Okay.
Yes.
All right. Okay.
Kind of start that process, so.
All
Thank you.
right. Glad to see you're doing well.
Thank you, Your Honor.
You take care.
Yes, Your Honor.
Court calls case People versus Irvin Patterson.
Casey Burke, Your Honor, on behalf of my client, Irvin Patterson.
Wow. She didn't do it this time. She didn't do it. You know, it's great. If you just keep after them, they learn. And it's good to see when they do. Warms my heart.
Happy to do it. Thank you, Your Honor.
All right. Your name, sir?
Urban Patterson.
Thank you, sir. All right, what are we doing?
Your Honor, we are seeking an adjournment. It looked like we had the wrong phone number, so we were unable to contact my client, but we now have the correct information.
All right. Probable cause conference will be adjourned August 1st, 2024, 9 a.m.
Thank you, Your Honor.
All right, thank you. Bond continued.
Thank you,
sir.
Your Honor.
You're welcome, sir. Court calls case of the People versus Theory Reynolds.
For the people.
Assistant Public Defender Natalie Pate with on behalf of Mr. Reynolds, who is approaching.
I'm doing well. Your name?
Theory Reynolds.
Thank you.
Thank you, Your Honor. We are respectfully requesting a brief adjournment of this matter so I can have a meaningful discussion with my client.
August 1st, 2024, without objection, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Ryan Scarcliffe.
Mr. Canatra for the people.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Scarcliffe.
Yes, ma'am.
And would you say your name, sir?
Ryan Scarcliffe.
Thank you. Okay, what are we doing?
Your Honor, we are in negotiations with the prosecutor and would ask for a 1-week adjournment. I'm hoping that we can resolve it in a week.
Okay, I can give you 2 weeks if you think you'll.
Pardon me?
I can give you 2 weeks. If that will work.
Shall we do? What works for you?
1 week if we could, but 2 weeks if necessary.
Okay.
So would you decide?
So if necessary, we will do 2 weeks that we can do, but a preference for 1 week.
Yeah, I know. But you don't want to see the docket next week.
Okay.
All right. So I'm going to put it out to July 25th.
Okay.
2024, 9 a.m. or as your invite indicates, bond will continue. Okay.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Devin Schiller.
Mr. Canatra for the people.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Schiller, who approaches and stands to my right. Mr. Schiller, would you state your name for the record?
Devin Matthew Schiller.
Okay, what are we doing?
Your Honor, I'd be asking to adjourn the probable cause conference. There is a bond violation that I assume the court has seen.
Yes.
So I did speak with my client regarding that. I did indicate to me that he did have a relapse a few weeks ago. He has begun going to, is it Narcotics Anonymous, NA meetings?
They're technically A, but it's kind of like a mixed group.
Right. So he's going to meetings. He's been to, I think, 7 meetings in the last about 10 days. He did provide me with some sign-in sheets to verify some of the later meetings. Additionally, it looks like Community Corrections has referred him to outpatient. He has an intake for that on July 15th, which he will be attending. He continues to test, knowing that those levels are going to reduce, but they will eventually be testing.
Well, I don't have levels. And I mean, I have 3 consecutive tests of fentanyl.
I read on.
When did you start this programming that you kind of created for yourself?
So he started attending the AANA meetings in late June after he had his relapse. He had thought that this was something he could manage kind of on his own. And then he has
we're gonna
realized.
have to find something, Mr. Allen. We're gonna have to find something else.
Judge, I'm going to ask the court to consider adjourning this and give him an opportunity to stay on the path that he's on. He has a referral for outpatient, which is not something that he was doing, and that was the recommendation of Community Corrections. If he's taken into custody today, that's going to derail the treatment plan that he has in place, and it's only going to delay.
It to the extent it's a treatment plan. I mean, what it is it's his notion of what to do. But I've got 3 consecutive testing of.
Your Honor, may I say something?
I don't think that's a good idea.
Okay.
All right, Your Honor, he was at one point a high user. In that instance, it takes time for the levels to reduce. For the levels to reduce. We don't know what the levels actually are, but the report indicates that those can be sent out for testing to determine that the levels are in fact reducing.
If I look at this testing, I don't think he's ever stopped.
I have.
Because the first the first test, since this case anyway, because the first test, he is an unable or refuse, there's no test. And then 3 consecutive tests, he's testing positive for fentanyl.
And Judge, he reports the last time he used was in late June. Those numbers are reducing. If the court will allow him, there are going to be negative tests coming. He has an intake for outpatient treatment at community
Fentanyl
corrections.
won't stay in his system that long. That means he's continuing to use.
I promise you, it will be negative next week. When you're a chronic user, I read online that it can stay in your system for up to 4 weeks. I haven't been using in multiple weeks.
Somebody needs to come back with a plan for his release, but he's going in right now. You're not going to have three tests coming back
The
like that.
levels are gone.
You can argue with me if you want.
I'm not gonna
Bonds revoked, defendants remanded. I'll set it over to next week, the 18th, 9 a.m.
Thank you, Your Honor.
So I don't have no left. I have no left.
Who was that? Get security down here and find out who the heck that was, because they're not going to walk out of my courtroom that way. Who? Did you see who just came out of the courtroom, Joe?
I did not. I was in the comments.
Okay.
Black.
It's a woman in a black t-shirt. If she was down in courtroom C, I want her brought back. Court's gonna stand in recess. You may be seated. Court calls the case, People versus Frederick Baez.
Your Honor, Amy Rides, everything on behalf of people.
And Your Honor, Joe Simon, on behalf of Mr. Baez, state your name, Frederick.
Frederick Baez, Your Honor.
Thank you. I never noticed that his hair is almost the same color as his shirt. I'm sorry, I was just observing.
It's wisdom, Your Honor. That's what I tell my children. It's wisdom.
It's wisdom.
Yes. Anyway, Your Honor, we request the matter be set for preliminary exam. Request the date, I know how you prefer that, of July 30th, if available.
And now discovery is complete.
Yes, well, actually, we adjourned several times for a supplemental discovery that was never materialized, but nevertheless, we're asking for that date because we need to
move this along.
Yes.
Yes. Is it because it doesn't exist or it's just?
Outstanding question. That is our best belief standing here today. There was a supplemental interview that was requested that we don't think materialized because
I don't think the witness was able to be interviewed, so it doesn't, it wasn't adjourned it for that potential to be done, and it was not.
Got it. And the witnesses would be available on the 30th.
Yes, to the best of my knowledge. If they're not, for some reason, I'll let Mr. Simon know. I'll send.
Preliminary examination will be set July 30th. That was the date I picked. 2024, 9 a.m. in person before
Judge Freshour.
Judge Freshour.
Your Honor, one request on bond. My client, who's been very compliant with bond, is there's a family wedding for his cousin in North Carolina. His parents are at an age where they prefer he drive them, and so he's asking permission to drive his parents out of state July 24, return July 29.
24th to 29th.
No objection to that.
All right. I'll amend his bond condition. Defendant may travel to North Carolina. Those dates inclusive. You'll finish it.
Yes.
Okay. All right. Thank you.
Thank you, Your Honor. Wait for me outside. Thank you, Fred.
Court calls the case People versus Raymond
Kachida, Your Honor.
Kachida. That's exactly what I was going to say.
And Your Honor, Joe Simon, on behalf of Mr. Kachida, go ahead and state your name.
Raymond Andrew Kachida. Kachida. All right. Thank you.
Your Honor, we're asking, I've supplied some materials to Mr. Childers for his consideration. Actually going to supply him more, asking to adjourn the probable cause conference to August 8th.
Why is he picking dates?
Because I know that's your preference.
No. You're just trying to get on my last nerve, aren't you? I've had a day.
No, Your Honor, of course not.
He does it one more time, Ellen. Just take him. Probable cause. Let me pick a date. August 8th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls the case People versus Michael Natinsky.
Yes, Your Honor. And Your Honor, Joe Simon on behalf of Mr. Natinsky. Michael, go ahead and state your name.
Michael Natinsky, Your Honor.
Thank you.
Your Honor, this is a case where I've supplied some medical information on the client's background to the people. Mr. Goodrich and I, pardon?
August 8th.
Thank you, Your Honor.
Gonna beat him to the punch. August 8th, 2024, 9 a.m. Bond continued.
Choice.
Court calls the case People versus Carrie Scott. What is this, a Simon hour? Is this it? Is this all?
Joe Simon on behalf of Ms. Scott, I'm so sorry. Carrie, state your name.
Here, Scott.
Your Honor, this matter we're requesting be set for preliminary examination.
He's gonna want the 30th.
Your Honor is wise.
If he comes in doing this again, I'm gonna let him slide for today because I'm a kind soul. All discovery is complete.
Yes, Your Honor.
And people would have their witnesses available on the 30th. Preliminary examination in person, July 30th, 2024, 9 a.m. before.
It's you.
Before me.
Thank you, Your Honor.
You'll be okay. He may not. Don't worry about it. Bond continued. There's another? You told me that was it.
No.
Yes, you did. And here we are with the song. Court calls the case People versus Lath Shama.
Your Honor, Joe Simon on behalf of Mr. Shama. Lathan, you can state your name.
Please, Shama, Your Honor.
All right. I have a plea form in front of me. Is that what we're doing?
Yes, Your Honor.
Yes, sure.
That plea form indicates that defendant will be pleading guilty to attempted fleeing and eluding for the 1 year offense. To that charge, count one would be dismissed. There is a sentencing agreement to HIDA. People do not object to no upfront jail.
All of that's true, Your Honor.
I can't bind the court to whatever extent that is, but
And I did explain that to my client. He understands and he signed his sentencing judge waiver as well.
have him sworn.
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Please, Shama, Your Honor.
Does he have an advice rights?
I did a fresh one today and turned that in. Should have it. Let me just double check. I'm pretty sure. Your Honor, I apologize. I apologize.
Wow.
Thank you.
Wow.
Sorry.
And all my staff looked like they had.
Didn't deliver the goods. Sorry.
Ann was going to take it on the chin.
No.
No, she was. You were trying to hurt my staff. That's
Never-
okay.
never do.
No, that's okay. No, you're going to fail. All right. Sir, it's this court's understanding that you are going to be pleading guilty to the charge
Yes, Your Honor.
of attempted fleeing and eluding. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine for court costs. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A4 District Court.
I do understand, Your Honor.
All right. Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
No. So, officer.
No.
Guilty, Your Honor.
That's right.
All right. Now you understand that by pleading guilty, you will not have a trial.
Yes, Your Honor.
You signed an advice of rights form that your attorney was reluctant to give us. Is that correct?
Yes, Your Honor.
All right. Do you have any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you deployed to this charge?
No, Your Honor.
Anybody threaten you or coerce you in any way?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Where's my see, guys, just keep hiding it. On June 1st, 2024, at the location of US 23 near Carpenter Road in Pittsfield, or in the city of Milan, Washington County, state of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
What happened?
Saw the officer's lights, got scared, fled, came to my senses, stopped.
All right, so you saw the officer's lights, you knew that they were attempting to try to pull you over,
Yes, Your Honor.
and then at some point you realized, as you said, you came to your senses that that was pretty, not a good idea,
Horrible idea, Your Honor.
and then you pulled over.
Yes, Your Honor.
All right. And you traveled some distance. Is that correct?
Yes,
Before
sir.
you did decide to pull over?
Yes, Your Honor.
Counsel, have I complied with the court rule?
Yes, Your Honor, you have.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 3rd at 9 a.m. before Judge Fresh Hour.
September 3rd, 2024, sometime 9
9 a.m.
a.m. before Judge Fresh Hour.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you.
Thank you. Rid of me now, Your Honor. I would say, Your Honor, that's the long and the short of it. So,
Yes, it is. All right. Take care, Mr. Sang. Court, that's called the case of the People versus Michael Smith.
Andrew Childers.
Assistant Public Defender Hannah Apple, appearing on behalf of Mr. Smith. Mr. Smith, will you state your name for the record?
Michael Smith.
Thank you. Your Honor, if we could have an adjournment, there's some information Mr. Smith has provided me with today that I'd like to have a discussion with the prosecution about.
Probable cause conference, August 1st, 2024, 9 a.m. Or as your invite indicates, bond will continue. All right.
Thank you.
Sir. Good.
Court calls the case People versus Kirby Snyder.
Andrew Childers appearing on behalf of people.
Oh, he's back.
Jacobs are on behalf of Kirby Snyder
Hold on. Where's your supervising attorney?
in her office. Try to do the whole rule thing again.
What the heck?
I thought I heard you say earlier I didn't need to do it.
Did I ask that? Oh, lo and behold, she decides to mosey in. She's here. Go ahead, counsel. Go ahead.
So
You have no idea what just happened, do you?
no.
Yeah, I didn't think so.
No.
I don't want to hear that again.
Okay.
I mean, I don't need to.
Oh, sweet. We're on the same page. All right. I'll be
You're
asking,
not even in my book. All right, but go ahead.
all right, Your Honor. I'd ask for an adjournment in this matter considering my client told me she's in the hospital and we've requested documentation of her being at the hospital, but have not received it. At this
How do you know she's in the hospital?
We don't specifically request the documentation, but have not received it.
Who contacted you?
Please contact us. Yes.
It's like a little parrot. I have a violation report, though. Are you aware of that?
Yes. And I will say,
Okay.
my client, earlier in the year, she voluntarily admitted herself into rehab and completed 80 days. So that shows that she may be compliant for future community corrections testing.
When did she go into the hospital?
Good question.
Did she tell you that? The reason I'm asking is because she was ordered on 7/1 to go to community corrections within 24 hours. So she should have been there by 7/2. I'm now at 7/11. She's not reported to community corrections. You're indicating she's indicating to you she's in the hospital. But even before going into the hospital, it seems she hasn't reported to community corrections.
Yes.
And although she called, you don't have any documentation.
No, currently waiting on that.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000. Cash surety won't issue immediately, but I will look at setting it aside if if information is provided regarding the defendant's hospitalization, as well as some reason why she didn't appear at community corrections.
Thank you.
Thank you. Before you were here, Miss Anderson, I asked him where his supervisor was. He very dismissively said, "I don't need her." I'm just telling you what he did. I'm just saying what he did. I heard him. He threw his hand. Okay, yeah, okay, all right, good. We're all on the same. Court calls the case, People versus Jonathan Starr.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Starr, who stands to my right, please state your name for the record, sir.
Jonathan Starr, Your Honor.
Thank you.
Thank you, Your Honor. We are respectfully requesting a 2 to 4 week adjournment in this matter. We have provided discovery to Mr. Starr, and we're just asking for some time for both him to review it and us to review it together before setting this for exam.
August 8th, 2024, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls case People versus Keith Stewart.
Andrew Childers, grant on behalf of people.
Joy Gaines, Senior Assistant Public Defender, representing. Your Honor, we
Your
have.
name, sir?
Oh, I'm so
Keith
sorry.
Stewart. All right.
Your Honor, I have had some discussions with Mr.
Is
Childers.
it hot out today?
I think it must be.
It must be, because everybody doesn't have pants on.
Yeah, and I apologize. I didn't.
I probably shouldn't have put it that way. Everybody has.
He does have shorts on.
Yes.
Just does not have.
Okay.
He has
I'm
long
curious.
shorts.
I haven't been outside.
He has
but-
long shorts on.
Okay. All right.
We've started having some discussions in hopes of coming to a resolution. We'd ask for a couple of weeks adjournment so that we can continue to work towards that.
All right. Very good. August 1st, 2024, 9 a.m. Bond continued. All right. Thank you, sir.
Thank you.
Court calls case People versus Jeffrey Stoops.
He's on.
He's on.
Andrew Childers, grant on behalf of people.
Oh, there he is. Thank you.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Stoops, who is present via Zoom. Sir, can you please unmute and state your name for the record?
Yes, ma'am. Jeffrey Stoops.
Thank you.
Thank you. Thank you, Your Honor. Likewise, in this matter, we are respectfully requesting a 2 to 4 week adjournment. Mr. Stoops also has been provided discovery and wishes to review it. We are asking for 2 to 4 weeks for that to happen. Thank you, Your Honor.
August 1st, without objection, 2024, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you.
Thank you, Mr. Stoops. You can log off now.
Thank you. Have a good day.
Court calls the case People versus William Sumler.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Sumler. Mr. Sumler, Your Honor, Mr. Sumler and our office played phone tag for the past few days. I did receive a message indicating that he did not have transportation from Detroit to get to court today. So I did request for him to appear by Zoom. I reached out to him and was only able to leave a message, but I thought that our paralegal was able to reach him and get him the phone number, or probably not the phone number, the Zoom information.
What is those last three digits?
500.
500. What because I have a 313 with a 500 as the last three. I don't know if that.
I think that might be it.
What happens when you try to prompt the phone?
It should tell them.
Oh, okay.
I'm present, Your Honor. I'm present, Your
Okay,
Honor.
what's your name?
William Sumler.
Okay, that's it.
Your Honor,
I was
we are
trying to
asking
figure
for-
out how to unmute my phone.
Okay, all right, gotcha. Go ahead.
Your Honor, we would ask for an adjournment so that we would have some time to discuss the case with Mr. Sumler.
Without objection, probable cause, August 8th, 2024, 9 a.m. Bond continued.
Thank you.
All right, thank you, Mr. Sumler.
Thank you, Your Honor.
Court calls case People versus Brandon Ventura.
Maisie Berger, Your Honor, on behalf of my client Brendan Ventura. Unfortunately, we have tried to make contact with our client for the past few days, emailing, calling, text, and we've gotten no response. So today I'm very respectfully, please begging for an adjournment from you today.
She says that so nicely.
Thank you.
Easily. That's not really. That's where release prevent failure to appear. Bond is set in the amount of 10,000. Cash surety. That warrant will issue immediately.
Thank you, Your Honor.
You're welcome. Court calls the case People versus Kareem Washington.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Washington.
Your name? Kareem Washington.
Your Honor, today, Mr. Washington will be waiving his right to a preliminary examination. There was an offer for him upon waiver that would occur in circuit court, that upon a successful plea to count one, count two would be dismissed and no objection to IDA.
Got it.
We do have the signed waiver form.
Okay. Sir, is that correct?
Correct.
And you understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with two following.
Your Honor, we acknowledge receipt of the information, waive its reading on the record. At this time, my client wishes to stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 21st at 1:30 before Judge Conlon.
August 21st, 2024, 1:30, Judge Conlon. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Bethany Wilson.
Senior Assistant Public Defender representing Ms. Wilson, coming forward.
Your name, ma'am?
Bethany Wilson.
Thank you.
Your Honor, at this time, we are requesting a preliminary examination.
All discovery is complete.
That is my understanding, Your Honor.
And will the people have their witnesses available the 23rd? Preliminary examination in person, July 23rd, 2024, 9 a.m. before Judge. Bond will continue. Thank you.
Thank you.
Court calls the case People versus Mateus. Is it Wojciech?
Good afternoon, Your Honor.
Good afternoon.
Assistant Public Defender Hannah Apple appearing on behalf of the defendant. Your Honor, I'm asking for an adjournment at this time. We've been playing phone tag. We got some updated phone number just this week. So I would ask for an adjournment for that reason.
Probable cause conference without objection, August 1st, 2024, 9 a.m. Bond continue.
Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you, sir. All right. We're good.
Yes.
All right, court stands in recess.
All right. All right. The 14A District Court for Washington State of Michigan is now back in session. The Honorable Judge CEDRIC Simpson.
May be seated. Court does call the case. That we were doing. The People versus the Cravion Wells.
Good afternoon, Your Honor. Marcia Crater on behalf of Mr. Wells. This is except for a probable cause conference. Mr. Wells is clearly not present. I would ask the court. He has, I've had contact with him.
You have?
Yeah, not today though, but, okay. But I've had contact with him. I would ask the court to graciously grant a 1-week adjournment. Graciously asking, humbly asking.
Bench warrant will issue for defendant's failure to appear. Bond 10,000, cash surety. That warrant will issue immediately.
Thank you, Your Honor.
No, you don't mean that, but okay. You're welcome. Calls the case People versus Hamad Williams.
Good afternoon. Good afternoon, Your Honor. Marcia Craich on behalf of Mr. Williams. Mr. Williams, can you please state your name?
Lamar Williams. Thank you.
Your Honor, I've had an opportunity to briefly discuss this matter with the Madam Prosecutor. We're asking for a 2-week adjournment so that we can enter into possible further plea negotiations, Your Honor. Just a second.
That objection, probable cause, July 25th, 2024, 9 a.m. as your invite indicates, bond will continue.
Thank you, Your Honor.
Thank you, Ms. Williams. Court calls case People versus Wardell Smith. Really, Kelwald?
Yeah, he was sitting here and then he just got up and decided to leave. Is Mr. Kilowald ready? If he's not, then I'm just.
You being the most gracious and understanding judge. Judge, I just heard him pull in the park.
I heard, yeah, but probably not on the bad tires you've got. I heard that you were supposed to get out and get tires. And so I was trying to call your
I'm
case.
more worried about my client. What? I'm more worried about my client's safety, so I told him not to rush it, but I'm sure he's just pulling in the driveway.
Okay, I'll pass it, but I don't want you going out on bald tires, like skidding into.
I've always thought you were really
skidding into like my car. That's all I'm really worried about. Thank you, Mr. Kilowald. Let me know when you're ready. Oh my. Court calls the case, People State of Michigan versus Tommy Lee Clark Jr.
Why is that? That's the wrong Carol. I'm sorry.
Wrong, Carol.
Yeah, they must put the wrong one in there.
Okay, that's all right. Then I'll do it. I'll do it up.
It's Jessica Mullins in there.
Court calls the case People versus Jessica Mullins. So I don't have it. I needed to. It's on the Mullins case. Oh, my friend, you're breaking up on me.
Can you hear me now, Your Honor?
Yes, sir. That's better.
On behalf of Ms. Jessica Mullins, who's not present in court, Your Honor, and I'll address that matter today.
Okay, she's not here. All right, and bench warrant will issue for.
If I can make a record, Your Honor, just to make a brief record, Your Honor, I will state that Ms. Mullins informed me that she originally enrolled in Sacred Heart inpatient treatment. Unfortunately, to this date, I have not been able to get verification. She texted me 2 days ago and said that she had to leave Sacred Heart and go into Oakdale. I contacted Oakdale. I have no information of her being in that program. And so those are my representations to the court. But as of today, Judge, I have no information of her whereabouts.
All right, very good. Thank you. Bench warrant will issue. Bond 10,000 cash surety. Warrant will issue immediately. All right.
Thank you, Your Honor.
Thank you, sir. What's the issue?
I apologize. Like that, I don't know.
Court recalls the case People versus Ahmad Williams. Because calling it once wasn't enough, apparently.
Your Honor, Mr. Williams wanted me to address an
Who
issue.
did?
Mr. Williams.
Oh, he did.
Yes.
Okay.
He requested me to address an issue of bond, which is he has a temporary medical marijuana letter that I presented. He would ask the court to allow him to use medical marijuana or marijuana. I guess it's not medical anymore.
Well, regarding that, typically take no stance. I would indicate that. Have you presented the card or the letter to Community Corrections?
I don't believe so. He just showed it to me today, Your Honor.
Well, he needs to present it to Community Corrections. I'll place it on the record on the Carol, so to be a JIS when they look.
Okay, I will send him over to Community Corrections so he can present that to them, Your Honor. Thank you.
Thank you. Court calls the case of the People versus Esmond Britt.
Morning or good afternoon, Your Honor. I'm having a hard time hearing your courtroom. But Leslie Knapp appearing on behalf of the defendant.
Okay, and are they here? Yes, they
Oh,
are.
Mr. Britt is on Zoom. Yes.
Sir, can you state your name, please?
Esmond Britt.
Okay. And what are we doing on this today?
Your Honor, we're still waiting on not competency, criminal responsibility determination. So I'm asking if we can put this out maybe 6 weeks We've received nothing.
I don't know that they're going. Did you receive the competency report?
Yes. I believe. But we also requested a criminal responsibility. Oh, wait. Yeah, the last I have, Your Honor, is a letter dated May 15th indicating it's going to be a while before we get the criminal responsibility.
Have the June
Determination.
21st. Do you have the June 21st competency report?
No, I do not.
Okay.
Okay.
I believe the court has it.
I do.
So we received the competency report indicating that he's competent to stand trial, but I don't have the criminal responsibility either. I can send this over to Ms. Knapp, and then if we could adjourn to enter a finding on competency.
All right. What I'm going to do is I'm going to adjourn this out a couple of weeks. Ms. Hughes is going to send you a copy of the competency report. I don't know when they're going to do the criminal responsibility reports because they're behind on the competency reports as it is. So I'm not sure how they're ordering things. And typically at this stage, I'm not dealing with the criminal responsibility reports in any event.
Oh, okay. Well,
all right.
I'm not quite sure why they wouldn't have sent that to me, but it is what it is.
Yeah, I don't.
I'm not shocked Mr. Britt is competent. I kind of expected that. It's been almost a year and he's on the appropriate medications now, but be that as it may, I'll obviously need to review that.
Review the report, correct.
Yeah.
So what I will do is I will adjourn the competency hearing over to July 25th, 2024. 9 a.m. Bond will continue.
Thank you, Your Honor. Have a good
Thank
weekend.
you.
It was okay. Take care. Bye.
Thank you. All right. Thank you, Mr. Brett.
I'll call Yasmin.
Okay. Court calls the cases of the people versus John Garrett. 3 cases.
Ms. Apple, if you want to.
Go ahead, Ms. Julian.
Erica Julian appearing on behalf of John Garrett in 24 F5 5561 FY.
And Assistant Public Defender Hannah Apple appearing on behalf of Mr. Garrett in the other 2 matters. Mr. Garrett, will you please state your name for the record?
John Garrett.
Thank you.
Your Honor, it is my understanding that this is going to be a waiver of preliminary exam and that there should be waiver forms in the file.
On all of these?
On the 2 that the Public Defender's Office represent, I believe.
My case is waiving as well, but I'm not sure that I have a signed form in the file. I can get one to the court, but at least for the record today.
I have Ms. Julian, I have you on 2 files. Is that correct?
No, Your Honor, it's just the 5561. The other 2 are deliberate cases. I just have the possession. There was a witness in the possession, but not in the delivery.
We may have written it wrong. Yeah. That's all right. That's okay. All right. Mr. Garrett?
Yes.
Is it your understanding that you're waiving your right to have a preliminary examination in all of these matters?
Yes, Judge.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
Okay. You understand you will not have that hearing and that you'll proceed to circuit court on these 4 charges?
Yes.
All right. People, for the record, waive their right on all of these cases?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 and 2 in the case ending in 5143, in the case ending in 5142, and the other matter ending in 5561. He's bound over on the single counts.
As to the arraignment on the cases that the Public Defender's Office represents him on, we would waive any additional reading. My client would stand mute. We acknowledge receipt of the information.
We would do the same, Your Honor.
All right. Defendant having waived formal reading, standing mute to all. Court will enter a not guilty plea. Pretrial in these matters will be set for
August 20th at 1:30 before Judge Kunke.
August 20th, 2024, 1:30.
Bond on all these matters will continue. Thank you.
Thank you.
Thank you, Judge.
Thank you, sir. All right, can you get these other two? Yeah, most of it done. Court calls the case, People versus Ronald Henderson.
Full case on behalf of the people.
For the record, Erica Julian appearing on behalf of Ronald Henderson. Ronald, can you state your name for the record?
Ronald Henderson.
Thank you.
Your Honor, this is a waiver today.
The waiver.
Yes, Your Honor.
Mr. Henderson, is that correct?
Yes.
You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offenses alleged were committed and that you committed.
Yes.
And you understand you'll not have that hearing and you'll proceed to circuit court for further proceedings.
Yes.
People also waive the right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 following.
Thank you, Your Honor. We acknowledge receipt of the information. Waive a form of reading. He stands mute.
Defendant having waived form of reading, standing mute. The court will enter a not guilty plea as to all charges. Pre-trial will be set for
August 19th at 1:30 before Judge Slay Monday.
August 19, 2024, 1:30, Slay Monday. Bond will continue.
Thank you very much, Your Honor.
Thank you. Court calls the case People versus Katana Hudson Curtis.
And good afternoon, Your Honor. Good afternoon to your staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Katana Hudson McCurtis, who stands to my right. Ma'am, please state your full name for the record.
Katana Nadine Atiana Hudson McCartis.
Thank you.
Thank you. All right, what are we doing?
Judge, if I may?
Yes.
Oh, excuse me. Haven't had an opportunity to speak with brother counsel, Judge. We're very close to a resolution, Judge. The letter saying we're humbly asking for an adjournment of the PCC probable cause conference. I do believe my client's already waived her 21 days. However, she's fully been advised, and if not, wishes to waive so today, Judge.
All right. Probable cause August 1st. Will that work?
Yes, Judge, please and thank you.
August 1st, 2024, 9 a.m. or as your invite indicates.
Thank you, Judge. Always a pleasure. Have a great day.
You do same, Bond. Continue. Court calls the case of the People versus Thomas Hornberger.
Good afternoon, Your Honor. Robert Ellman with and on behalf of Mr. Hornberger.
Your name, sir?
Thomas Hornberger.
Right.
Your Honor, today's date and time set for PCC. I would at this time like to set this matter for an exam.
I would set it for an exam, except that your client hasn't been tested.
I understand, Your Honor, and I am in receipt of the bond violation report.
Why hasn't he been testing, Mr. Allen?
Your Honor, he missed one test, the first test on the day that we had court due to his misunderstanding of what time court was. And after that, Your Honor, I don't have a good answer.
Well, just so that we're clear on the bond violation, on the June 12th, he did take a test, tested positive for cocaine, fentanyl, and THC. And then the next 3 successive tests, he missed.
And my understanding, Your Honor, is that he thought after missing one test that because that was a violation that he did not need to test further. I've advised him that that was a mistake. He wishes a further opportunity to test on this matter.
You wanted to set for a preliminary examination?
Yes, Your Honor.
Is all discovery complete?
Yes, Your Honor.
People have their witnesses available the 23rd? Preliminary examination in person, July 23rd, 2024. 9 a.m. That's before Judge
Washington.
Washington. You can't just decide you're going to test, not test, do whatever, and particularly have a dirty test and then miss all of the other tests. At this point, defendant's bond is revoked, defendant's remand. Go with my bailiff, sir.
Come see you soon, Mr. Hornberg. Have a good day, Your Honor.
Court calls the case, People versus Kanasia Johnson Jackson.
Robert Mullen on behalf of the staff.
Your name? Yeah. And this is actually, I think, a time for a PCC and your motion to withdraw.
Yes, sir.
All right, go ahead with your motion to withdraw.
Your Honor, I put most of the important facts that I think that are necessary. If the court wants details, I'm more than happy. But I believe based on the rules, if I have a financial hardship and continued representation, the court would take that as a reason for withdrawal. But more importantly, if I can withdraw at a time which will not create any kind of substantial hardship on behalf of the defendant, and I think that would be the case here. We do have all the discovery that we think we're entitled to at this time, but we have not had a preliminary exam. And I don't believe that any of my clients' rights have been prejudiced.
And Ms. Johnson Jackson, anything you want to say regarding Mr. Mullen's motion to withdraw?
Yes, I don't agree with it.
Pardon?
I don't agree with it.
Okay, what don't you agree with?
Just based off the that was provided to me in reference to, can I see your paper? The email that you sent me this morning.
You want the motion? You want didn't you read me something?
Yeah, that's what I'm talking about, the email that was.
Hang on.
Thank you. So this morning, the email that was sent, which is what I'm about to read, it says the defense counsel appear on behalf of the defendant with the understanding that defendant will be remitting forthwith to defendant counsel a retainer payment as agreed upon by defense counsel and defendant. The second one was defendant subsequently failed to remit said retainer payment, nor has defendant indicated when the retainer will be paid. 1 second. The third one is an attorney may withdraw if his client fails substantially to fulfill an obligation to the lawyer regarding the lawyer services and has given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. So in reference to all that, yeah, in reference to all that stated, the retainer, so him and I, it seems like there is confusion between him and I in reference to the retainer fee and just like the distance of my case. Does that make sense?
No.
So I don't agree. So what he's doing is a motion, right?
It's a motion to withdraw as your counsel.
Right. So I don't agree with the motion to withdraw in reference to this is my probable cause hearing, right?
Well, it is a probable cause hearing, yes.
Right. So, okay, so I have a question. So with him withdrawing as my counsel, are we still doing this today or is that postponed?
If he withdraws, okay, ma'am. So I have to make a determination as to whether or not there are grounds to withdraw.
Understood.
As I'm looking at it. So I asked, Mr. Mullen stated his position. I have the motion in front of me, and I'm asking what your position on this motion to withdraw is.
Oh, I absolutely disagree. And to my understanding, it seems like most of like videos and just maybe more statements have been given to my defense, but to my understanding, that is the discovery, but I don't know anything about it because him and I haven't spoke about it. Does that make sense?
Okay, it could, yes.
Okay.
So, ma'am, let me just ask you this. His basis of withdrawing is that you were supposed to, you had certain financial obligations. It's indicating that you haven't fulfilled those. I don't need to know what those specific terms are because it's not relevant to at least the court's determination at this point. Are you indicating to me that you did fulfill those obligations? And therefore, okay, but fully fulfill those obligations?
I haven't fully fulfilled obligations, but I have put money in his hand. So that's why, yes.
Okay.
General, may I respond just, or do you want me just to be quiet?
Go ahead.
Yeah, she's right. She's paid me some money, of course. But the reality of it is it's less than a third of what the retainer understanding was an agreement for this case. In addition to that, I haven't paid anything in almost 3 months. There's been no efforts to pay me. I've had multiple meetings. I had a meeting on the 26th of June specifically to make this a focus. I don't like talking about money. I'd rather work as a lawyer and do the work on the case and have those meetings. But as you know, it becomes a conflict of interest when you're not being paid. This is a capital case. She's entitled to substantial work on this case as it being a capital case. And when I'm not getting paid, I don't know how I'll be able to do it. This is not like an OWI where even if I'm not getting paid, I could probably suffer through it and it wouldn't damage my practice or my mental health. This would be maybe a little more of a different of a situation. But to say that she hasn't paid me any money,
I don't think that you said that.
I just want to make it clear she has, but she has not even come.
That's not what I got from this. I get it. So, ma'am, are you telling me? I understand that you've paid part of what's there.
Yes.
Okay. But you haven't paid what the entire amount agreed upon was.
You said what the entire amount?
What the entire amount, you haven't paid that.
I haven't paid the entire amount.
Okay. So are you telling me that you're going to?
What I'm saying is there has been some confusion in reference to the amounts. There has been efforts, multiple efforts to make payment, and I have made payment. I have not made the entire amount. But
so let me just ask you this. As to the entire amount that was requested to obtain of the retention, why hasn't the full amount been paid?
Because there was confusion on the full amount.
Your Honor,
I don't know what that means.
Miss Johnson Jackson wrote me out a payment schedule. This was her schedule. It wasn't my proposed schedule.
Yeah.
She wrote me out a payment schedule and provided it to me and has not even lived up to that. And like I said, less than a third of the retainer in the case. And just so this court knows why I'm a little nervous on top of it is, and I explained this to her, I have a bifurcated billing system. Part of it's a retainer, that's a flat fee. The other part is an hourly when we get into motions and trial. And the fact that we're having such an issue with just the base retainer, I'm nervous. We go further in this case. We get into trial, we're going to have an hourly bill that's going to be accumulating, and I don't have confidence in that bill being paid timely. So hence the motion.
Ma'am, is he right? You laid out an agreement that you were going to pay?
We did have an agreement.
Ma'am, can I ask you why you just don't answer my question?
Because
I think my questions are rather simple. Mr. Mullins has indicated you laid out a payment schedule to him. Is that right?
Yes, but it wasn't the total amount being asked. The payment plan that was laid out was not the total amount that is requested. And so when I understand, when I say that there is confusion in reference to it, usually, for instance, people will sign a retainer fee with the lawyer, and that didn't happen. So once again, I did give him money to counsel me. But as far as the total amount, it wasn't.
Then ma'am, explain to me something.
Mm-hmm.
If you haven't done that part,
Mm-hmm.
why shouldn't I grant his motion and just let him withdraw?
Because this is the probable cause hearing.
Because what?
This is the probable cause hearing.
Okay, and I give you another probable cause hearing. You won't be in any worse position.
Okay.
Because that's his obligation. His obligation is not to put you in a worse position when he goes to withdraw. And so that you understand what Mr. Mullins is really saying, and maybe he says just more fancy way than I would. He doesn't want to get to the point where either you're not paying him or something else happens in the case, and then he's either stuck because he can't have you in a safe spot, Or he just has to try to get out to save himself, and you're gonna be in a worse spot.
I understand.
So can you tell me a reason why I shouldn't let him out?
So I have a question. Can I ask a question?
Sure.
So let's say that you ruled that he in his favor. So so I would be given a.
Ma'am, let me stop. I'm gonna tell you what I'm going to do, okay? And that way we can just put this to an end. I'm gonna grant his motion to withdraw. I get it. I think you're a little bit worried that you're gonna be left out there on your own. Here's the PCC and whatever. Doesn't work that way here. So I'm gonna grant Mr. Mullins' motion. Mr. Mullins is withdrawn from the case and further discharge of any obligation of this client or the court on this matter.
Thank you, Your Honor.
This now becomes a public defender case. You're represented by the public defender at this juncture, okay? That way you still have counsel, very capable counsel to represent you in this matter. Ms. Anderson.
Thank you, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Ms. Johnson Jackson. Your Honor, I asked for a couple weeks adjournment for us to get discovery and speak with her about the case.
All right. Probable cause conference in this matter will be adjourned to July 25th, 2024 at 9 a.m. or as your invite indicates. Okay? Ms. Johnson Jackson, you understand?
Yes.
Okay, so you've got counsel now. They'll get the discovery. They'll be able to go through it with you and pace through it. It doesn't mean if you want to hire another attorney or somebody else, you can still do that. But you've got very, very capable, extraordinary counsel to represent you. So,
I understand.
okay. And so bond will continue.
Thank you, Your Honor.
Thank you.